Morning. And welcome to Minkah-Premo, Osei-Bonsu, Bruce-Cathline, and partners. We are very honored to have all of you here in this morning. But indeed, it is with great pleasure that I welcome you all to this morning's panel discussions themed Arbitration versus Litigation, focusing on the factors that businesses should consider when deciding between these two forms of dispute resolution. Businesses and commercial disputes are almost inseparable. Indeed, business and commercial disputes rise and fall in lockstep. Finding creative, affordable, and speedy ways of resolving disputes that arise from doing business is therefore important to both business owners and legal practitioners. The choice between litigation and arbitration may theoretically be a very easy one, but then we all know that in practice, it is not. For both dispute resolutions have their merits and demerits. The challenges faced by our courts are well documented and indeed do show and does include heavy case loads which lead to unintended delays among others. Some have also pointed to the cost associated with arbitration, which could sometimes be extremely prohibitive as a factor that could deter the use of this dispute resolution mechanism. Which way to go in the event of a dispute is therefore not a very easy question, but I'm sure that after this morning's discussion, it will unravel that. And it will also show us and also provide further insight into the things that should excite the minds of legal practitioners and also businesses when they have to decide which of the two options that they need to settle on. I am extremely confident that after this morning's discussions, we will surely draw some useful lessons that should guide future, that should actually guide us in the future on the choice of dispute resolution mechanisms, whether in the drafting of agreements and contracts or in the event of a dispute occurring between two contracting parties. Here at MPOBB, because we have a very long three partners with compound names. So just made MPOBB. We are in the business of helping our clients make this all-important choice between litigation and arbitration. In the over 27 years since we have started, we have offered services in these areas such as corporate and also corporate, commercial law, intellectual property, real property, and many others. The firm has a formidable dispute resolution team that has over the years been engaged in some of the most very complex corporate litigation and arbitration, both local and international. There's no need for self-adulation, as our reputation as a firm of great repute in these two areas is a matter of public knowledge. I thought this is where the guy can get a lot of applause. Indeed, some of our senior partners, Mr. Justice Minkah-Premo, who incidentally will be a member of this panel, is an embodiment of our experience and knowledge in these areas. I am certain that his contributions will enrich today's discussion, and I personally look forward to hearing his almighty thoughts on this subject matter. I am also certain that the members of the panel will do justice to the topic. I would like to encourage all persons present to participate actively in this morning's session. I am confident that all of us here will leave today's discussion with a renewed vigor that should make a future choice between arbitration and litigation, a far easier one to make. This morning's meeting is a consequence of the collaboration between MPOBB and the UKGCC and the London Court of International Arbitration, LCIA. And I believe that future collaborations of this nature will help unearth solutions not only to the question posed for this morning's discussion, but in all other areas that will mutually be beneficial to the business community and the legal fraternity. MPOBB therefore welcomes any future collaborations that will assist in this regard. Once again, I welcome you all to Minkah-Premo, Osei-Bonsu, Bruce-Cathline, and partners for this morning's session. And I wish all of you fruitful discussions. Thank you. I think this is where you take over from me. I guess, right?
Yes.
Okay.
Thank you everyone for joining us this morning. I would like to welcome our panelists to join us on the call. I'm just going to start with Ms. Mariana. Who is the president of the London Association.
Hello, everyone. So I have the honor of introducing my fellow panelists. I'm not sure I'm the right person to introduce these distinguished panelists, but I'll try. May I invite the Director General of London Court of International Arbitration, Jackie, to join us. And also Mr. Nathan Sell, who is a partner at Hogan Law London. If I could introduce our moderator, Ms. Leila Ahmed from Triple OK in Kenya. And last but not least, the big man himself, the founder of Minkah-Premo, Mr. Justin. I think Leila and I should switch so that before we switch, or I think this is convenient, I'm supposed to say something. I really don't want to, but I don't have a choice. And people have told me to say something. So I just wanted to give a brief introduction to who we are, what we do, and why we are here. So as most of you know, but before then, please, can we give a huge round of applause to Minkah-Premo? And also to the Ghana Chamber of Commerce. We are so grateful that you've agreed to host us here. This event would not have been possible without you collaborating with us. So thank you so much. And I've been to your offices several times, but I haven't been since you moved. And it's such a beautiful facility. So congrats to all of you. Now, as most of you are aware, the LCIA, as we call it for short, it provides dispute resolution services around the world. And although it's tagged or has London in its name, it offers a truly international service. So it's not London focused or UK focused. It really is international. And this is reflected in the fact that about 80% of pending cases before the LCIA have non-English parties. Their nationalities are not English. So that really reflects the international nature of our service. Now, where does the African Users Council then come in? The LCIA thought it best to set up users councils who will put together programs of activities for members and users in particular region. So the African Users Council obviously caters to the African region. And the LCIA is very keen in developing a closer relationship with users, with legal practitioners, arbitration practitioners, businesses, in these regions. And that's why we are undertaking a roadshow. So we are in Accra this week and we'll be in Lagos next week. Of course, we have to come to Accra first. And so far, that the, my colleagues have had a wonderful time here so far. Now, the African Users Council, I just want to introduce some of the members. I'm really, really blessed to have such an amazing team. And I'll start with Mr. Nathan Sell, who I already introduced. He's a partner at Hogan Lovells in London, and he is the vice president. We also have Mr. Jigre Abushokan. He's right here. Maybe you can get up so that people can see you. And Jide is a partner at Stevenson Howard in London. We have Madam Noella Lubano, who is a partner at Oraro and Advocate in Kenya. And then we have, of course, Leila Ahmed, who is a senior associate at Triple K. Now, we didn't come alone, we came in full force. So apart from the Users Council members, we also have the co-chair of the Young International Arbitration Group of the LCIA, Madam Minkah-Premo. She's a partner at Ashford in London. And we also have our regional representatives. So we have Aditola, also practices from London, he's originally Nigerian, and then we have a Peace. And Peace is also based in Nigeria. We have Dr. Adimola Bamboshi right here. He is he's a senior associate at Hogan Lovells London, and he used to be a regional rep, but clearly outgrown that role. But he stuck to us like glue, so he's here with us. And before I end, I really have to introduce someone special. He was my predecessor. He's he has really blazed the trail for arbitration in Africa. That's Mr. Kamal Shah. He's the partner at Stevenson Howard and the head of the Africa and India practice of the firm in London. So welcome to everyone. This would, of course, not be complete without Jackie. As I've already said, Jackie is our Director General, and I want to say a few words about Jackie so that we know just how amazing she is. So Jackie is a very distinguished arbitrator and has been Director General of the LCIA since 2014. Before this, she practiced as counsel and arbitrator at The Hague, at her own boutique law firm, and prior to that at Freshfields in Amsterdam. Jackie handles cases under all leading arbitration rules and is on the excellent roster of arbitrators. How much better does can that get? And then Jackie is also a professor of arbitration law at Leiden University and a member of the Global Arbitration Review's editorial board. This is Jackie's first time in Accra. I can assure you she has enjoyed it. So together, can we say Aquaba to Jackie? I'll give Jackie some time to say a few words to us.
Well, thank you very much for that unnecessarily and positive introduction, but it is truly a delight to be here in every respect. My first trip on behalf of the LCA was to East Africa, Uganda, and since then I've been back a few times. And one of the reasons why it is so important for the LCA to come to the continent is that we feel that through the Users Council, we are able to connect with users so that these visits are genuinely worthwhile for the users and for the LCA. And Nanya and her predecessor Kamal combine so many things, not only great legal skills, but effectively they are tour operators. When they run these roadshows, they're in charge of the bus, you know, you get emails and messages that have to be at reception at 5 to 9. But it is thanks to the meticulous planning, and I always say people's attitude in relation to events shows you how they conduct themselves also in their cases and how they serve their clients. It is the dedication to detail and keeping in mind the bigger picture that makes them wonderful people to work with. Thank you, Nanya, for briefly identifying some of the key features of the LCA. Indeed, it is an international organization based in London. And in this day and age, you know, with Zoom and virtual facilities, I don't think it matters too much where the secretariat is based. The point is that from London, we serve users all over the world, and that very much includes African users from all over the continent. I would say with a bit of an emphasis on Anglophone Africa. That's not, you know, as far as we are concerned, necessary. We have perfectly equipped Francophone equipe as well, but in practice, the bulk of the cases we get from the continent tend to come from Anglophone countries, including very much Ghana. Maybe useful, given the setting, given that this is an event in cooperation also with the Chamber of Commerce, it's interesting always to look at the type of cases that particular institutions tend to get. And historically, the LCA has been quite strong in 3 sectors: banking and finance, energy, and commodities. In the last couple of years, we have seen that commodities is firmly the #1 sector, and that reflects the developments globally in relation to energy prices and off the back of that, commodity prices. There's a lot of volatility, and that leads to disputes, and the wording of contracts can become extremely important. How is force majeure defined in the contract between A to B, and how does that differ from the wording in the contract from B to C? Maybe there are incompatible dispute clauses. That's one of the areas that we may touch on in the discussion amongst the panel members. When I look at the Ghanaian and Nigerian cases, I think the 3 sectors that I identified are very much the key sectors also for these countries. So that's something I'm keen to explore with you. What I also would say about the African cases is people seem to mix and match applicable law and seat of arbitration. And I think that's very helpful. It's not a given that you choose London and English law, or that you choose Accra and Ghanaian law. You can mix and match depending on the nature of the contract, the nature of the parties, and the bargaining position of the respective partners. And as far as the LCIA is concerned, we are agnostic. We will support wherever the arbitration is seated and whatever the applicable law is. So with that very brief introduction, I would suggest we move to the meat of this discussion under Leila's guidance. Thank you very much.
All right, good morning. Good morning.
Good morning.
Why are you all down? You need a cup of coffee? All right, this is also my first time in Ghana, and I've come with some cash. I have money. We need to do a quick survey, right? I'm going to give each one of you $1 billion, right? Quickly, you need to enter into a commercial agreement with, you know, these are the billionaires of the continent. What will be your choice of dispute resolution? Litigation? Litigation? Anyone for litigation? Mediation? Arbitration? The people who are not interested in business at the end. Will I kindly find out what you're interested in? The gentleman at the back? Do you have any choice of law? Yes. Arbitration. Why arbitration?
Because you have money.
Because I have the money. Okay. That is Kamal. Where will you go for arbitration? All right. Anyone who wants to share with us, Noella, why you're choosing arbitration?
I think because it's fast. I think my problem with the courts is they can be very slow.
Okay.
And also, I like the fact that you have a bit of control over a number of things.
Okay. Yeah. Okay. Thank you, Noella. The aim of this panel discussion is to provide businesses with a clearer understanding of how to navigate these two predominant methods of dispute resolution, right? I think from this survey I've done, I'll keep my money. So, Nanya, I would just like to start with you. Could you kindly tell us what is the predominant dispute resolution mechanism in this jurisdiction?
Certainly in Ghana, I have to say litigation. A lot of people, when they are thinking about being lawyers, it's about going to court, wearing a wig and gown, going to defend someone or fighting someone. And I think predominantly people are used to litigation, but in the past 5 years, there's really been a conscious, an intentional shift towards arbitration. And I have to say that even when I teach at the law school, and you see a lot of enthusiasm amongst the young people for arbitration. And clearly, I have done litigation. I did litigation for 7 years before I started working on arbitration, and I've seen a rise in arbitration. I mean, a huge rise in arbitration matters. So I think we are slowly moving away from litigation to a point where lawyers are looking at complementary forms of dispute resolution, including mediation. You can find people using mediation now. So we are going towards people seeing different tools in the dispute resolution toolbox rather than focusing solely on litigation.
All right, thank you, Nanya. Nathan, what's the position in London?
Again, I think it depends on the types of disputes. At its core, arbitration is an agreement between two parties. So where we see commercial parties, particularly from different legal cultures or jurisdictions, and where you're looking to enforce the decision around the world. With the New York Convention, arbitration awards are enforceable in over 160 countries in the world, whereas in my jurisdiction, if I take an English judgment, there are very few places that I can get reciprocal enforcement. So I think that's a big driver. Where we don't see arbitration so much is where it's difficult to get that agreement. So consumer type claims and those class actions. So there are some limits to arbitration. We've got two commercial parties. They can agree their process for dispute resolution, and it's all about, as Noella said, the parties taking control.
Now that you have the mic, are there certain disputes that are more suitable for arbitration or litigation and vice versa?
Again, as I've already touched on, it's all about agreement. So where the parties, commercial parties particularly, can reach agreement on the process, they can tailor arbitration to their needs. It's really those areas where you need the court's involvement. So winding up and certain consumer actions. But even where you have arbitration, there's also a role for the courts, because sometimes the arbitration clause doesn't work and you need court support. Sometimes you need to get freezing relief, to get injunctions. So the court has that jurisdiction to grab those assets, and if the party doesn't apply, they'll be in contempt. And certainly at the back end, a huge number of arbitration awards are voluntarily complied with. But where they're not, you need the courts to be able to enforce in the same way that they would enforce their own judgments.
Thank you, Pastor Mike, to Mr. Minkah. I just want to find out what are the advantages. I know you're a litigation guru of heart. The advantages and disadvantages of litigation, especially practicing in Ghana.
Well, litigation in Ghana See, that's what's arbitration is costly.
Jackie, I bring you to weigh on this. Arbitration, is it more costly than litigation? What's your view on that?
Well, I think there's, I think it is a nuanced, or it's a question that deserves a nuanced answer. Of course, in arbitration, you typically pay the arbitrators and the institution, although that may be different in certain quality type of disputes. But in the end, in court litigation, although you may think that court fees are quite limited, if you look critically at all the costs, it can actually be considerably more. And one of the main reasons is that in arbitration, there's typically no appeal. And as Nathan said, typically awards are enforced, so you don't go to court afterwards. So it's one instance. That means fewer, more limited costs on counsel, but quite importantly for the business, it means that the time that they need to dedicate to a case is more limited. And that's a cost factor, which is often overlooked. Having management keep an eye on an ongoing piece of litigation is really costly. So I think at the end of the day, it depends on the type of dispute. It also very much depends on the type of arbitration. Some institutions charge on an hourly rate basis, such as the LCIA and ICSID. Others, such as the ICC, pay arbitrators and the institution on the basis of the amount at stake. And that means that you're often talking about apples and oranges when somebody has done, for instance, an ICC case involving a huge amount of money, but a fairly discrete legal point. They may say, well, it was a lot of money for a 2-day hearing. Whereas if they had had a very long hearing about a very complex case, an ad valorem system may, relatively speaking, be less costly. In the end, with institutions such as ICSID and LCIA paying arbitrators an hourly rate, there's another factor. These institutions also cap the rates. I think some of your comments, and I'd be interested to hear more from you, are really going to ad hoc arbitration. And if there's one thing that makes arbitration more expensive, it is not having institutions involved. Now, the LCA is not for profit. So unlike some of the lawyers in the room, at the end of the day, I'm neutral about whether you want the LCA or not. But if I look at the numbers and if I look at the cases I handle as arbitrator in ad hoc and institutional cases, I can genuinely tell you that an institution limits the costs because they keep an eye on the progress of the case, the efficiency of the arbitrators. So I think we need to be careful not to extrapolate, for instance, bad experience in an ad hoc case with arbitration more generally. Leave it at that for now.
Thank you.
In terms of litigation, as Nathan said, there are some cases that are well suited to litigation, like consumer actions and all of that. But and in our context, of course, constitutional issues will definitely be resolved by litigation rather than arbitration. If you look at Section 1 of the ADR Act, there are certain things that are not arbitrable. Environment, interpretation of the Constitution. So that aside, I think for businesses, one of the important considerations would be whether if they go for litigation, the judge in question has the specialized knowledge for that particular type of transaction that's being handled. And I'm not talking about normal commerce. We know that now we have all of these really specialized industries. We have fintechs, we have crypto and all of that. And as much as we have in our high courts, we have like the commercial division. The commercial division deals with a broad range of matters, and you may not necessarily have a judge who understands cryptocurrency. And so if you take your case before the courts, you may have to spend quite a bit of time trying for the judge to be able to even understand the type of transaction in question. On the other hand, if you were to go for arbitration, because you are able to participate in the selection of the person who is going to hear the matter and decide the matter, you could, for example, look for certain skill sets in the person who is going to decide the matter. And that significantly impacts the outcome because they understand the underlying transaction. For example, if the transaction is for putting up like a nuclear plant or something like that, you really do need someone who can understand the intricacies. If you have a huge building project, you need someone who has, depending on the type of dispute, it may not just be, you did not provide the proper materials, but if it has something to do with engineering and all of that, you sometimes need that specialized knowledge so that you ensure that you get the results that you're seeking. And in that instance, you might consider arbitration rather than going for litigation.
Thank you, Nania.
When it comes to litigation, let me use Ghana for instance. It's triggering a lot of state-sponsored and state-sponsored institution. As against arbitration, it's rent a judge, rent everything, right? So all things will improve. Arbitration will be more costly. Now, except that, of course, when it comes to expertise, certainly going by arbitration to avoid it. And
just to add to that, I think I agree with you. But I think one thing too that we don't factor in, and I think that Jackie touched on that, is the constant appeal in litigation. I mean, I have a matter that I've been handling for 6.5 years now. We only have a Court of Appeal, and I'm sure we are definitely going to the Supreme Court. And even that, we will get a review of the Supreme Court's decision. And so I think that in as much as the court is comparatively maybe cheaper, I think if you look at the long run, the aspects of appeal coming in, the time, sometimes by the time you're done with the case, the business is dead, it's gone. And so that may be something that you want to factor in. Let's say maybe in arbitration, it's a bit of front loading of the cost, but when you think about the time spent, the appeal process, all of that, it may end up, I mean, I'm quite certain that it may end up being cheaper if you have gone for arbitration.
Nathan, I know both the justice and Nanya have touched on the issue of cost. Should businesses then engage in a comprehensive financial planning when they are considering which dispute resolution mechanism to choose?
Yeah, absolutely. And I think that's what we see with businesses who are really looking to proactively manage their risk, is that they've thought about the types of dispute that they're going to get into and where the best value is. Arbitration, it's a bit like a car. You can drive it in first gear, but it's not very efficient. It comes back to what Jackie said. The arbitrations can be very different. And whenever I'm asked, is arbitration more expensive than litigation? The typical lawyer's answer, it depends. But what does it depend on? It depends on the choice of the lawyers and of the parties. I've been in arbitrations, thankfully very rare, that are run just like litigation, under the court rules and is rent a judge. However, I've also seen arbitration where it's done by documents only. So there is that flexibility. This is a low value dispute. We're just going to send it to the arbitrator, send him the paper, him or her the papers, and then the arbitrator will render an award. We have Zoom, And we can use that very efficiently. We don't have to be flying people around the world. And I did an arbitration fairly recently where each side had one important witness where credibility was important. So they attended in person, but others, we save huge amounts of money by having it on Zoom. So what I would say is that sophisticated parties are having this conversation with their lawyers. And just because, for example, you've got an arbitration clause that says, it's a ICC rules, 3 arbitrators, hearings in Paris, you don't have to, you can think, actually, we've got this very small dispute. It's all in relation to events in Accra. We're going to try and agree to change it. It's more difficult at that stage. So the best, what I've seen the best of our clients doing is have a little 1-page, this is what we asked for in relation to dispute resolution. Yeah. For claims that are above this amount of money, or involve international counterparties, we're going to have arbitration, and this is what we have. And sometimes I'll even have within the arbitration clause, first, we're going to try mediation or discussion, because it's a lot more cost effective if you can resolve your disputes without going to arbitration. And then for arbitration, if it's below this amount, we'll have 1 arbitrator. If it's above this amount, we'll have 3, because ultimately it's about the cost you're willing to invest in the process. And if there's a large amount of money at stake, then you want a more robust process with 3 arbitrators. So I think it's very much about businesses talking with their lawyers, not when it's happened and you've got a clause you have to try and renegotiate, because things are very difficult to agree at that stage. But to be thinking, actually, rather than just looking at whatever my lawyers put in the boilerplate in my agreements, I have a preference. And some clients say, well, this preference first, and then this later. And as Jackie mentioned at the outset, sometimes it's also linked with what seat do I want, or what governing law am I willing to give something up? And so I think if there's one takeaway for business people and the transactional lawyers, it would be sit down with your disputes colleagues and have a plan, have a think about this, so that you understand what you want out of your dispute resolution before you get there.
Thank you. Speaking about cost and the specialized knowledge, what other key considerations should businesses have in mind?
If I might, I was just going to add one element that I think follows from what Nathan clearly outlined. It is about what is realistic. It's all very well to say, in an ideal world, I would like, in my case, I'm a Dutch lawyer, I would like to go to the Dutch courts because they're actually very quick and efficient, and the taxpayer supports a lot of the fees. But you can't always get everything. And I've been surprised how, if you do the analysis that Nathan outlines, I've had clients that I'm actually willing to concede the law. I'm happy to accept Italian law. It's not good for me, but okay, in the end, for the issue and dispute, it may be that you are happy to give up the law, but not the seat, or the other way around. So it is all about informing yourself what the options are and then trying to negotiate what is optimal. Now, in terms of the other building blocks in thinking about the benefits or the concerns about one system or the other, we all talk a lot about confidentiality. And I think confidentiality is an important factor to consider when you consider arbitration. You should say, do your homework, because as much as we talk about confidentiality, most international rules are not explicit about confidentiality. The LCIA rules are very explicit about this, but the ICC rules, for instance, don't. So then you need to look at the arbitration law and the seat to see if that law supports your expectation of confidentiality. But that can be a huge benefit for both parties. Because of course, again, think about the negotiation environment. You want to think about what is in the interest of both parties, and often that's confidentiality. A factor can be the choice of arbitrators, directly or indirectly. It may be that having an institution select the arbitrators gives you a certain amount of comfort that you'll get arbitrators with knowledge, but not necessarily too closely connected with one of the parties. So think about how you would like the selection process to work, and then again do your homework to see how the relevant institution sets this up by default, so that you know what you need to put in your contract. The key advantage, of course, is enforcement, but I think that's something that has already been raised and we can go back to. I'd like to focus on the modalities. In terms of modalities, for me, the biggest plus in arbitration is the flexibility. You can speak English, even if you're Dutch. You can make recordings, you can have court reporters, you can have Zoom for part of the hearing or all of the hearing. So you can make it your process much more than you can in court. And it's quite interesting to see that in England now, the courts are actually quite keen to learn from what is working so well in arbitration. And they are, for instance, when it comes to evidence, in a way taking inspiration from what is working well in arbitration, in the same way that obviously in arbitration, you are informed by how proceedings work in litigation, but precisely because it's international and people will be used to different systems. If you have good counsel, you'll be able to pick and choose and come up with something more flexible and able to protect the interests of all parties rather than just one party.
Mr. Justice Minkah, it appears that my three panelists are saying, go for arbitration. Is there anything good in litigation or business choosing litigation?
Arbitration, if you want to go that way for business people, then you should treat your contracts like marriage. Parties entering into marriage to save it will normally consult counselors, go for counseling, and those who think about the end also go for pre-options, making sure that the clients they will part company. So if you're doing or entering into a transaction and then you are formulating all your agreements and stuff, just as you have the experts in the area, you also need a litigation lawyer, particularly for your dispute resolution groups. If the person thinks beyond the presence, certainly you're going to have a better dispute resolution groups. I tell you from experience, a lot of lawyers would ask me, call it boilerplate, they just dump from one contract to another. Meanwhile, it is talking about, except is talking about, LCIA is talking about, ICC rules, and you've never read the rules. Right? If you're doing litigation, you're a local person, you know your rules of course. But if you're going to do arbitration, you come upon arbitration of choosing. You need to know your rules. You have to get the skills, right? Know the idea rules. And how many rules of litigation do you want to know? This is why the business person should ensure that apart from the experts in the area of your business, you need also litigation in formulating the transaction. That way, you can be certain that your arbitration clause will be drafted. Else in Ghana, you can stuck. we find we end up finding arbitration very costly.
Just to add to that, I think generally in Ghana, business people are minded to agree on the important terms. How many goods items are we supplying you? How much? Within what period? Those are the most important things to them. And once they are agreed on that, they have, they have a drink, say cheers, are happy, and move on with their lives and leave everything else to the lawyers. But I think the takeaway from this, from what Mr. Minkah-Premo is saying, certainly business people should take an interest in the dispute resolution clause. It's not just about the important terms that you are drafting into the agreement, but you need to take time, not alone, but with a lawyer, and understand what the two parties want to achieve through the dispute resolution method. And I think Nathan mentioned it, and I can't stress that enough. If you choose to go for arbitration, please see an arbitration lawyer. It's not enough to engage any other lawyer, maybe like an energy lawyer or whatever, to help you draft the contract. And you think that because the person is a lawyer, it's sufficient for them to look at the arbitration clause. It's just like if you have a problem with a particular part of your body, you will go to a specialist a specialist doctor to see that it's the same thing. And I think that really is the defect we have in our system. And we are all, we are all guilty of it once in a while. When in my firm, one of the things that used to happen several years ago was that you would review it, and whichever department was reviewing the contract will review the whole of the contract. But now what happens is that where there's an arbitration clause, it will come to the arbitration people to look at it. So you sort of want to, as a business, you don't want the dispute resolution clause to be what we term the sunset clause. It's like, the last thing on your mind, and then you just put it in. But you really want to take it as seriously as the amount of money you are paying under the contract and the goods and items that you're supplying.
Nathan, there is an argument that parties achieve more balanced outcome in arbitration as opposed to litigation where it's a win-win situation. I like your comment on that.
Again, I see them as complementary, and it comes back to the level of control that the business people want over the resolution of their dispute. So I think you do have a win-win in arbitration, particularly where a key difference is that you go to court, you get assigned a judge. That judge will have their own background, but they may not be a specialist in the area that you want. Also, if you have two parties from different jurisdictions, one party is often in their home court. And we see that particularly in a region like West Africa, where you've got civil law jurisdictions and common law jurisdictions, and they approach things such as good faith very differently. So what I found my clients appreciate is having someone on the tribunal who can understand their business environment, who can understand their industry, their sector. And even if the outcome isn't the one that they hoped for, they can live with the outcome because they can see that their points were understood, and they felt that they had their voice heard. I think from that they just feel that they have more control over the process, and for a lot of commercial clients, that's important.
Jackie, are these two processes mutually exclusive? Do the courts play a role in arbitration at all?
Again, if I might also follow up, because I heard your question, but perhaps I misheard. to go to the point, sometimes people say that in arbitration, arbitrators split the baby, they come up with a more equitable outcome rather than a reasoned, legally based decision. And I wanted to come back to that point because I think that's a myth. I do see that a lot of clauses that provide for arbitration may provide for preliminary mediation or negotiation, perhaps more than you see in conjunction with litigation clauses. But once it gets to arbitration, certainly for the arbitrations I see the decision-making process as very similar to what you see in court. I skim read every single LCIA award that is issued. So it's about 350 awards a year. And they are meticulously crafted legal decisions. And there's not like, well, let's just do 50-50 for the sake of it. Of course, if, for instance, in the context of damages or costs, the applicable law provides for a certain fluidity for the assessment of damages, for instance, there may be an amount that the arbitrators fix on the basis of the information they have, but that's not splitting the baby, that's not equitable, that is simply applying the law. So I just wanted to make that point, but I do see that might be different for certain smaller institutions that cater to the needs of users in a particular business or involving quality disputes. But for ICC, LCA, I don't think there's a real difference between litigation. But now the question that you wanted me to answer, I forgot.
Both you and I.
The role of the court.
Oh, okay, yes, and that's a really interesting one, because you might expect me, sort of as Ms. Arbitration, to say, oh, we don't want courts. No, we do want courts. I'm going to be spending my Saturday morning, the only part of this week that Namia has sort of left free, to look at the final version of the Arbitration Act, because I'm working closely with the Law Commission, because it is in our interest to have a good Arbitration Act and to define the role of the courts, because we desperately need good law and good judges to support arbitration. If there are uncertainties about the clause, we want to make sure that you get a good decision about whether or not there's a binding clause. You may need interim relief from a third party, and you may, hope not, but you may need to go to court at the end of an arbitration to seek annulment if there's a real issue, or to oppose enforcement if you think there's a real issue. So I'm certainly not advocating that you should go to court all the time, but it's extremely important that if and when necessary, you can go to court and that you get a good treatment, which requires good judges and good law.
Just wanted to piggyback on what Jackie has talked about. So just go back a little bit, talking about litigation and arbitration. And the fact that sometimes people have the misconception that with arbitration you get a balanced judgment, sort of trying to see where the balance lies and doing something that's good for each party. And I think that's a misconception we have here. By and large, I meet a lot of business people, even lawyers, who sometimes think that arbitration is sitting around a table discussing and trying to find a solution to it. But if you really want to understand arbitration, you should see it as private litigation. That's really what it is. So the same rigor that's applied in deciding a matter, that's the same rigor that will be applied in deciding your arbitration case. It's not just a sense of justice. They will apply the law that you have chosen. They will apply the rules that you have chosen to decide the matter. So I think especially for business people, please don't think that when you go to arbitration, I mean, yes, arbitration is informal in the sense that you don't have a judge wearing a wig and a gown, and you don't have your lawyers dressed up and, people saying my lord and all of that. All of those, let's say, frills are taken away. But in terms of the adjudication of the matter, the way, the steps you go through to actually decide a matter, it's the same as litigation. It's private litigation. So let's keep that in mind. And to add again to Jackie's point about us needing the courts, remember that if you have an arbitration award, the only way you can enforce it is to go through the courts. So the courts play a very important role. And if you think about the fact that arbitration is private litigation, except that the people here in the matter are not judges. They are normal citizens who have specialized knowledge in arbitration in whatever field. Imagine if you appeared before me as arbitrator and you wanted me to give an order, for example, compelling the other side to do something. If I gave it and the person failed to comply, what can I do? Nanya cannot go and get policemen to go and arrest them and say, well, I issued an order saying, or an award saying that you should pay Kofi this amount of money and you didn't do it.
You can do anything.
They'll probably ignore me. I mean, this little woman coming to tell me what to do. But what the court does is that it has that compelling mechanism. It's the only institution in the country that has that compelling mechanism to make people do what they don't want to do. If you don't want to pay, because the court has compelling mechanism, bailiffs will come to your house, seize your assets, sell it without your cooperation. The registrar can even sign off the documents and then pay the other person. And if you think about private litigation, although we can achieve a very speedy resolution of the matter, we do need the court's compelling power to get people to do what they ought to do. And that's a very important role. And also throughout the arbitration process, if you look at Section 39 of the ADR Act, there are provisions for the court supporting arbitration. So for example, if you need a witness to come to arbitration, you can go to the courts to compel that person to appear before the panel. If you need, for example, certain orders to go to take evidence, you can go to the court and get an order to allow you to do that. So the court really, it's like a marriage, between the courts. They need to cooperate to make arbitration work. So please don't think about it as we are pitting the courts against private litigation, but they all do work together to help us achieve speedy resolution of the issue.
Daniel, you mentioned one misconception about arbitration. Perhaps Nathan, to tell us other misconceptions in both litigation and arbitration.
I think one that we hear very often, and speaking up on what Jackie said about banking and finance being used for LCIA arbitration, is where you've got a debt. There's sometimes a misconception that there's no summary judgment in arbitration, and so you must go to the courts. But the LCIA rules and a lot of the other institutional rules, they'll provide that power for arbitrators to be able to determine preliminary issues and to make summary judgment type awards where there's no reasonable defense. So I think that's probably one that I see quite often. We've already talked about, do arbitrators split the baby? And again, my experience is it is that they're well-reasoned awards. Often there are retired members of the judiciary or very senior lawyers applying their minds to these issues. And I think also can be sometimes a conception that arbitration takes as long or longer than the courts. I think that depends on the jurisdiction. But again, in my experience, it all comes back to the parties and the lawyers. If they want a quick process, they can agree that. And I think the tribunal, particularly Again, this is where the institutions come in, where they have the institutional rules and the institutions following up on the arbitrators, that they have the tools available to ensure that there is a fair and efficient and speedy resolution of the arbitration. So I think a lot of that also comes down to the choice of selection of arbitrators, because you want arbitrators who are going to hold the parties to the timetable.
Just as what Nathan said, I mean, and I'm completely agreeing with him, because I remember in December I was having a discussion with a client, and his concern was that, oh, I mean, if you go for arbitration, it's such a long winding process. If you go to court, if they don't have a defense, you know, you can have summary judgment and all of that. And I was explaining to him that in arbitration we have early determination, where you manifestly, if you really don't have a defense, that process can be adopted. We have expedited proceedings as well, where for example, they give a specific time frame, and they have proceedings meant to expedite and get you to an award. So all of these are tools that can be employed depending on the rules, institutional rules that you choose to get you to your destination. The key is exploring all these options and not simply going in with a misconception that this can be done in litigation, but it can't be done in arbitration.
I think now that's all from our end. We'd like to open the floor for questions, comments, concerns. Any comment on the topic? Please come out.
I see them all.
Yeah.
Thanks. I have maybe 1 or 2 questions for you. We've been following from a distance under the increasing arbitration brought against the government here by the Chinese, by other investors and so on. What is your perception of how the judiciary views that, how the government views it? Because it's something that investors always look to when they to resolve the disputes. They want to go to arbitration and override both systems, because they're worried about delays, bias, corruption, any number of things, right? And I come from Kenya, so we have similar issues. So I just wonder what your take was on that. And also, there is a perception that in arbitration there's less corruption. In some countries, you can sway the judges, you can pay the registrars. I'm not saying that's the case here, but in many other emerging markets, it is. In Kenya, we have issues in the courts. I know in Nigeria too. So just my thoughts from me.
I think that our international government just expense countries. Certainly, you are talking about a host country and you want a neutral ground. That's why you choose arbitration. Of course, you're also dealing with a lot of expertise, so you choose arbitration. But, and in Ghana, for instance, all these Chinese companies are going to arbitration because the contracts stipulated the dispute resolution process, arbitration. The problem with that is that sometimes, like I said, we just duplicate what you find in some other agreements. Right? Assume that, in fact, they're all the same effects. Bribery, corruption. I think it's an African problem. And forgive me, so far we don't have much evidence of arbitrator corruption. But we have the courts. But if I look at the fact that someone who is paid fully and supposed to be protected from corruption by the kind of perks that they give them, if they are falling to corruption, arbitrators could. Recent cases of the Nigeria, and we don't know what's done. But all I'm saying is that if people protected or educators protected against corruption are falling, if you're not careful, you may see the same thing in arbitration.
If I might follow up on that comment, because I think it goes to a very important point that we need to be careful that we don't lose. I'm not saying that everything is good in arbitration, but insofar as it is good now, I think we need to be careful not to lose that. And I think this is exactly one of the areas where, again, you may need to do your homework a little bit because one arbitration is not the other. And again, keep in mind the importance of institutional arbitration. Not every institution is the same as another institution. But if you go to ICSID, the World Bank, LCIA, ICC, I think you have much greater safeguards than you have in other cases, and in particular compared with ad hoc arbitration. I hear of cases that do not take place in the setting where an institution verifies the fee notes of the arbitrator. And that's a completely different terrain. I'm not saying that if there is control, you will have a foolproof system, but so far I agree that it seems to work reasonably well. And I'm really concerned that people choose bad types of arbitration and that the bad experience that they may then have impacts arbitration and the perception of arbitration more generally. And it certainly goes to the issues you have rightly raised.
Well, coming back to what you said. In Ghana, you find talking about ad hoc. Unfortunately for us, it appears that what you see as ad hoc Ghana is seen as the standard for institution. Right. In our Arbitration Act, it chose to talk about Ghana Arbitration Center. And yet, there is an entity in Ghana, which is a company by committee, which bears that name. So, the tendency for people to just replicate putting Ghana Arbitration Center or Ghana Center for Arbitration there exists. And yet, when you get there, you will see that there are trends and incidents. So let me give you my own precedent case. In one case, they had a list of arbitrators. One of them was a retired judge who had retired on salary, so he was supposed to be earning maybe outside income. And for a mediation process, he was charging fees. And I asked him, I'm sorry, I thought you were not supposed to charge. He said, I'm charging for the center. That's okay, let's go to the center. How did we get you? The center who said that we were supposed to pay the resource person, right? Why did the ethics go? And I'm talking about someone, judge. So someone who is just aware and so what being a judge, not controlled by the same ethics, you can imagine. So certainly what we call ad hoc might differ. But I know when you say ad hoc, you're trying to compare LCIA, ICC, right, except to the others. But it is arbitration. It means that we must be as well.
Yes, there are a couple of questions. Unfortunately, this mic doesn't work.
Got three questions from those online. The first question is, there is the perception that sometimes there are biases. As an arbitrator, how do you deal with this and how do you stay neutral?
The International Bar Association has published guidelines on conflicts of interest in international arbitration. And what they've adopted is a traffic light approach. So there is red. That's a clear conflict of interest. Waivable red. It's a conflict of interest, but if both parties knowingly consent, then the arbitrator may proceed. There's an orange list, and then there's a green list. The green list is things that don't constitute a conflict of interest. And so that's a really useful guide because it provides transparency and clarity for the parties, for the arbitrators, as to the circumstances that will give rise to a conflict of interest need to be disclosed or simply act as a bar to accepting the appointment, and those which don't. But the key rule of thumb that certainly I and most arbitrators adopt when we think there might be an issue is to disclose, because that way the party, you're transparent with the parties, and then if there are circumstances that you think justify an allegation of bias, that's where we come back to the benefits of an institution like the LCIA that deals with challenges to publishers in an anonymized format, their decisions. Gives that certainty and that assurance. Where you don't have that, then you're back, as we say, into the courts, and the court support for arbitrators and challenging those where there is evidence of bias or incompetence that needs them to be removed. So I think that those are the sorts of the safeguards and protections.
I can perhaps follow up with some of the practicalities of how you deal with this. So one thing that institutions do, and again, this is a bit different than ad hoc arbitration, there are standard forms that arbitrators need to fill out. And that includes, interestingly enough, and importantly, also availability to make sure that people genuinely have enough time to dedicate to a case if and when they are selected. And they give information about potential cases, and really you better be safe rather than sorry. So we want these forms to be filled out comprehensively. And to give you a very concrete example, we keep an eye on, of course, these guidelines because they're incredibly helpful. Real life is even more complicated than these guidelines, so not everything is captured literally by what is on the guidelines. And when we see new concerns, we sometimes also amend form. And something we recently introduced, which the market hasn't really picked up, although I expect some people to start screening soon, is we've noted that some retired judges continue to sit because a lot of courts are quite busy, and people now after technical retirement sometimes still sit as judge. In addition, we have seen a lot of English judges take roles in judges in, for instance, Dubai, Kazakhstan, Bermuda, and we want to know that. A, because of availability issues, because they sometimes commit to very long stints sitting in court in these jurisdictions, but also, very importantly, for bias reasons. And some of the good practice we have seen is that people volunteer this information, and we now invite people and check to make sure that they, if they are on the roster of a particular court, that they let us know. Because it is tricky to appoint somebody as arbitrator in a case if they also are part of the court that might have some involvement in the case, whether for supporting with intermeasures or potentially even subsequent involvement proceedings. So that's something that we've recently introduced to implement some of the points that Nathan identified.
Just a short comment, they were asking as an arbitrator, how can you appoint that? Simple rule of thumb, if there are any doubts, disclose. Disclose, and let the parties decide whether they want you, they are comfortable, and they want you to continue.
Okay, thank you very much. The next question, what happens if the parties are unable to settle during arbitration? Do they then try other alternative dispute resolution mechanisms?
So if we remember that arbitration is private litigation, then we'll know that at the end of litigation, a decision is given, and that decision is binding. At the end of arbitration, the award is binding. And it's even more binding because unlike litigation where you can appeal the decision, in arbitration, you cannot appeal the decision. You can only apply to set it aside on limited grounds. So where, for example, you weren't given a full opportunity to present your case, there was some form of bias or whatever, those kinds of situations are very limited under the Alternative Dispute Resolution Act. That's when you can apply to set it aside. Otherwise, it's binding and you cannot appeal. And therefore, there won't be a situation where I don't want to use the word settle because in arbitration, we are not settling a decision, there's an adjudication and a decision is rendered. And whether you like it or not, that decision applies to you. So it's not that it's settled, but where a binding decision is given in arbitration, there aren't any other forms of dispute resolution that you can use. That's the end of it. So arbitration is not like, let's go for mediation, let's try this. If it doesn't work, then we try something else. Arbitration is binding, just like the courts. Once you choose it and the decision is made, the expectation is that you stick to it. You can't try something else. Of course, parties are always free to compromise. Even where a decision is made by a judge, parties may agree to compromise and reach, maybe, for example, if the decision is to pay 100,000, of course, the parties are free if they want to decide that, well, you can pay, if you pay 80,000 within a week, I'm not going to insist that you pay the 100,000. But remember that it's not likely that someone who has been able to achieve a high success will then later on settlement really happens before a decision, a binding decision is given.
I don't know if you have some tips as to how you can mitigate or deal with some of these issues that seem to undermine the whole intention of the parties agreeing to arbitration, so that at the end of the day, a client will tell you, this is good. Because the last time I did arbitration, it took me the exact same amount of time, maybe more, it cost me more. I didn't have party autonomy because of all the instances of court interventions in those arbitrations. So I don't have some tips or any comments on what can be done.
Thank you very much, Noella. I think the first thing is to draft a good clause. And I would say start with the model clauses that the institutions have. That's what I always tell my students. And they say, oh, but we want to be creative. And I was like, yeah. Now, if you have good lawyers, they will not make the same mistakes that my students make. But still looking at the basics that are provided for in the various institutions, simple clause, with options, and look at those options carefully. Do you want to fix the number of arbitrators, yes or no? Do you want to fix the language? Sometimes that's obvious, but sometimes not. And quite importantly, choose the seat. That is what these model clauses urge you to do, and that is vital. It avoids unclarity, and it helps you choose a law that functions. Again, my Saturday morning, insofar as the seat is England, you have the English Arbitration Act. The seat is Amsterdam. That's the law that you look at for procedural issues. It's not a foolproof system in the sense that for certain measures, you will be able or will need to go to other courts if there are assets elsewhere. You may able to interim relief somewhere else, but you can really contain the problems by having a good clause and a good seat and good lawyers.
The second question is, so if there's a contract and both parties decide that, okay, we are going to agree in the clause to have arbitration, to resort to arbitration if there's any dispute, can they, I think, can they decide not to go with arbitration, or if any of the parties decide not to go with the arbitration again and choose the litigation route, is that allowed? And thirdly, also, so if during the process of arbitration they decide that I don't think this is helping us anymore, can they resort to litigation? Thank you.
Then you hold on. Let's take the next question, then we'll answer all of them together.
So I want to know, is there any meeting or major points between arbitration and criminal law practice? Because it happens, so happens, and most of the time you realize arbitration practitioners are usually civil litigation practitioners. So I want to know if there is that instance. So there's a matter that's referred to arbitration, and then you realize, okay, there is this criminal law element. Let's give it to this criminal law aspect. It's equally does with arbitration. So I want to know if that happens and how often it does.
Do you have a question? What did you next to? Okay, that will be our final question. We need to wrap it up.
Thank you. So my question is, I guess as practitioners, as clients, the question of jurisdiction seat is always in that consideration, what issue legislation arbitration. What is more important to concede
Happy that last question.
Well, unfortunately, I don't remember. But I think I remember two things that you raised. The first is, I think you raised a question of stare decisis. And yes, in litigation, the court decisions are published. You know the reasoning, and appellate courts, their decision is binding on lower courts and everything. But if you think about arbitration as private litigation and the fact that it's confidential, then you can't have stare decisis, because it's the parties in the matter who will know the decision that was rendered. Unless, of course, the parties decide to publish their arbitration award, or sometimes when it's a government, there's a government involved, then the award becomes public knowledge. But if it's confidential and private, then it's impossible to have, stare decisis where one arbitral tribunal's decision is binding on the other. Although, for example, we have some institutions that have started publishing their decisions, it's not binding on another tribunal. They will have to, all of those will affect the outcome of the decision, and therefore it's going to be quite difficult to have stare decisis in arbitration. And if you think about it, under our law, we have an application for stay of proceedings in reference to arbitration. That is where only one party unilaterally decides to abandon the arbitration agreement and go for litigation. The other party has the option of bringing the arbitration agreement to the attention of the court.
Nathan, perhaps you could take the question on whether there's a relation between arbitration and criminal law.
Yeah, yes, I can certainly do that. I would just add to what Lani has said, that sometimes we see what are called unilateral option clauses, typically in loan agreements, which gives one party the option to choose between litigation and arbitration. You can see why that might be so if it's a lender, depending on where the assets are and what's going to be most beneficial to them. In terms of criminal law and arbitration, obviously arbitrators don't have power under criminal law. That's something that's exclusive for the exclusive jurisdiction of the courts. But where we see the overlap is where there are issues of fraud or corruption, where the arbitrators have to decide whether those acts of misconduct have occurred and what impact they have on the contract. So there are cases where there are those types of issues where there is a criminal act that is relevant potentially. So corruption, anti-money laundering, some slavery type issues in a supply chain. So that's where there is potentially overlap, and the arbitrators would benefit from someone who is able to explain what the criminal offences are, explain whether that conduct has occurred and what impact it has.
Happy to contribute to that in the sense that we increasingly see arbitrators who fill out information about their specialties as providing information whether they are familiar with some of the anti-money laundering laws that exist. And these are fairly technical pieces of legislation. And also sometimes you don't know in advance whether a case is going to involve issues of potential fraud or potential corruption, but sometimes it is quite obvious from the outset. And then it is helpful to know that judge members of the tribunal may have that skill set. Yes.
Is this a crime? But it's not a personal thing. You may want to have a contract with a private party. But crime is against the state. So you can't have that. And once prosecution starts, the only way you can rebuild the matter is with the leave of the court. And if the court allows them, you say, you're going to settle the matter out, right? And then report to the court, report to the matter else. You don't have that liberty. And if it's not a crime, and you want to treat it as a civil matter, of course, the parties can. Party to contract party power to settle it.
The final question from the gentleman, which we didn't get on conceiving on package.
The seats and what business people should be looking at.
Relevant narrative or procedure.
Yeah. So I think it very much depends on what's important in the context of the transaction. So where you have big differences in the legal cultures of both parties. So if you're dealing with a civil and a common law party, again, they may be more comfortable if it's a very detailed contract and straightforward that they're content giving up, one of the parties giving up the law if in order to be able to enforce an arbitration award, they're going to need to rely on the New York Convention, the Ohio Convention, and that they may be, that might drive the choice of seat. The other thing that drives the choice of seat is the supportiveness of the local courts and indeed the time with which challenges can be dealt with. So in England, you have to put in a challenge within 28 days and it's dealt with very quickly. In other jurisdictions, simply because of the public resourcing of the court system, you know that a challenge is going to take a lot longer. So those are all factors. Really, it's looking at the end. If something goes wrong, Am I going to be able to get the money, and what influence is the choice of law going to have on that, and what influence is the choice of seat going to have on that, and that determines the importance. For a loan agreement, it's going to be enforced, under almost any laws, so you may be much more relaxed, whereas a joint venture that requires lots of cooperation, you might need to understand what terms might be implied into that, so the local law might play more of a role. So that's why it's important to understand how these fit together, and that's where we came back to, the start was having a thought about what factors are going to go into the choice of arbitration, or litigation, or choice of law, having a company policy and thinking about what would my preference be, and able to prioritize those choices.
Well, when it comes to the choice of seats, I think that one is normally influenced by also the common law. I mean, if I'm choosing Ghana's common law, I'll prefer the seat to UK, because the laws are quite close. And no matter what you do in international arbitration, for instance, if you choose your lawyers outside, they'll still want to get local support. And if you are coming for local support, how would I be able, if I'm coming from the common law jurisdiction, right? And I chose seats in a civil law jurisdiction, because it's a problem. Whereas in that situation, we have to rely so much on experts. Witnesses. In the case of a situation where seats is quite close to local law, you don't need
I think in the interest of time, we'd like to wrap this up. I'll start with you, Mr. Justice Minkah. You're holding the marks on this topic. Just in a minute.
Well, litigation and arbitration are not mutually exclusive in the same documents. Do arbitration certainly end with litigation, unless maybe you're talking about litigation where enforcement become. But in arbitration, most times you end up not getting the judgments that was free. And so you end up going to court. So the two are not mutually exclusive. That's the points of confidence.
I think I'll just reiterate my opening remarks, which is that they are all tools in the dispute resolution toolbox. They work together well. And if you are a lawyer, you shouldn't think of yourself just arbitration litigation, but you need to think about yourself as being able to offer a full service to your client, and therefore it being necessary for you to discuss the various dispute resolution options of your client. If you're a business, you shouldn't think that, well, I'm used to litigation, let's just go to court. You want to think about the various options available and make an informed decision about what you want to choose.
And I'll just echo that. Your dispute resolution clause, take control of the choices. Don't just have your lawyers cut and paste from whatever last document they had and they use, but have on one page what the choices are and what your priorities and preferences are. And if clients and in-house counsel, working with their lawyers, can come up with that, it manages risk and it makes sure that you're in control of any dispute resolution process. So, well, as commercial, commerce breeds disputes. We never want to get there, but it's important, as the person said, to plan for the end, plan for the worst case scenario.
They're both arbitration and litigation tools in the toolbox. They're not mutually exclusive in the sense that for some contracts, you may prefer one, for others, the other. Inform yourself. Point that was made by Nathan, things have changed. Certain cases get disproportionate amount of attention. Some of the cases where everything goes wrong, I don't think that is representative. That is certainly in arbitration, maybe litigation cases that are blown out of proportion in the press. Inform yourself about the institution, the institutional rules, the law of the seat, and the applicable law, and then try to come up with a reasoned decision.
Thank you very much. We hope that you have a better understanding and you're now more informed. What I'd like to insist on and just clarify is that as lawyers, you have a role to play. Don't be a hindrance to the process, please. I think my panel did a fantastic job. Please join me in giving them a round of applause. And I think you are a fantastic audience. You deserve a round of applause. Thank you very much. I now hand over.
Thank you very much for joining us. And as Dana said, I hope you've learned something new that you didn't know before and got more information about arbitration and whether it's litigation. But yes, we do hope that you've had a very informative session. And for those online, thank you for joining us. Thank you very much.
Thank you.